I would like to suggest that when you're looking at a treaty or a statute, that you take a moment to think about the purpose of the statute, the structure of the statute, and the content of the statute. Those three categories help you to better understand why the statute or the treaty exists. To understand how the treaty is set up, and also to know and understand the content that's inside of the treaty or the statute. This can work, as I note on this slide, for both instruments. But in the case of treaties, which are so much a part of international law, it's always important to understand that the purpose is often related to the historical moments prior to the treaty and its founding. And so often there will be a preamble that discusses the prior international law and why this particular treaty is necessary. The structure of treaties is often very similar because after your preamble, you often have the operative sections, the sections that are binding on the parties to the treaty. But then there's usually some sort of an administrative section, a section that talks more about who's supposed to monitor the treaty or how to enter into the treaty, how to become part of the treaty. Those types of things will be discussed in a later section. And finally, in both the sections of treaties and also in statutes, there can be sort of post-treaty or post-statute, a part that might be a protocol, or in the case of a statute, an amendment. And this information, of course, is also very important and must be analyzed when you're looking at the overall treaty. Finally, the content of the treaty, of course, is very important. What rights are listed there? Who has the obligations in the treaty? Whose behavior is being regulated by the statute? And what are the consequences if you don't comply? These are all things that you would consider as you read through the content of a treaty or statute.